Welcome. This is video 3 of the Assessing Risk of Significant Harm training course for child protection practitioners. This video introduces you to the risk model, why it was developed and its various components. What is the risk model? The risk model is an analysis framework to support social workers and other practitioners to make good quality and consistent decisions about significant harm. I was once asked by a practitioner, how do I write a risk assessment for court? They'd been asked in court for a risk assessment, yet all the formats that they used in day-to-day practice were holistic assessments. They were told by the court that they should produce a risk assessment, not an assessment. When we thought about this question, we realised that a risk assessment in the context of child protection is an assessment of the likelihood of significant harm. At the time, there were no formats for assessment of risk of significant harm. Over several years, the risk model was developed to fill this practice void. Whilst the risk model was being developed, the final report into the tragic death of baby Peter was published. The Monroe report identified the principles that should determine practice in child protection. These included the importance of making high-quality decisions and for those decisions to be consistent. This reinforced what the risk model was aiming to promote: an analysis framework to support social workers and other practitioners to make good quality and consistent decisions about significant harm. In this training course, you will hear the terms threshold and significant harm used a lot. I'd like you to think about a light switch and a bulb. When the switch is on, there will be light. When the switch is off, there will be no light. So this is an absolute yes or no situation. It is either on or off. So threshold is a little like a switch. If we have threshold, if the threshold is met, we have child protection duties to investigate abuse. If we do not have threshold, we have no duties to investigate and interfere in the private lives of families. Our duty is to uphold a family's rights to privacy. And if we have threshold and are investigating, what are we investigating? We're investigating the likelihood of significant harm. We've described this threshold as being absolute. In Section 47 of the Children Act 1989, there is a duty on local authorities to investigate if they have reasonable cause to suspect that a child is or is likely to suffer significant harm. The on-off decision is reasonable cause or not. This is very important as it upholds very conflicting sets of human rights. On one hand, the state intervenes in the private lives of families. It is very intrusive. Families can't refuse to cooperate, and a child has an overriding right to be protected. And on the other side, families have the right to privacy, to be allowed to carry on without people knowing what happens behind closed doors. So we intervene only if we have reasonable ground. Unless we do, we have to respect private family life. Getting the decision right is about protecting people's rights. So let's start by asking, what is it? What is the risk model? Firstly, it's an overarching framework. Think of it as a mapped out system that has been worked out from law and case law, bringing information together in a timely way so you follow a structured set of questions. Bringing the information together like this helps you have sight of what you need in law to make decisions. And it's been created by practitioners, so we have a system that also works in practice. It has to be practical, or busy practitioners will never use it. It was created to make practice decisions about risk of significant harm. After the publication of the Munro Report, we realised it did this in a way that helped practitioners make high-quality decisions, and because practitioners were using a structured model, the decisions were much more consistent. This very much echoed the risk principles quoted in the Munro Report. Secondly, it's progressive. It starts by screening. Practitioners are encouraged to screen their whole caseload regularly, but for the screening to be simple and easy to apply. The screening is actually a single question. Do you have any concerns about significant harm? And then, if the screening indicates a need to, it is possible to undertake a more detailed risk assessment. But that work is only needed if evidence indicates that there are grounds to do so. So a more detailed assessment would be a 12-page assessment. So we screen everything quickly and simply, and then only undertake a full risk assessment on a few cases if that was necessary. It was developed by child protection professionals in Gwynedd Council's Children's Services in conjunction with Bruce Thornton, and was awarded a social care accolade by Social Care Wales in 2011 and a Bazoo Wales Award in 2013. It has been implemented in a number of local authorities in England and Wales and modified for use in family justice and early intervention. The risk model is screening, which is called Risk 1, and risk assessment, which is called Risk 2. But you may say this is complex work. What if I get stuck? What if there are particular aspects to the case that is specialist or complex? For example, if the assessment is pre-birth, or it's difficult to be clear about the significance of harm, or there is neglect or domestic violence. So the risk model has a number of extra layers beyond Risk 1 and 2. For example, the significant harm checklist can be used to expand your Risk 2. It explores severity and the meaning of harm. It was developed to help people write Section 7 of Risk 2, but has been used as a standalone assessment. It helps you identify the indicators and evidence of harm that is severe or substantial, and what additional meaning or inference there is to the harm. Severity and meaning are two key components of what makes harm significant. And of course, if your risk assessment is pre-birth, before a child is born and has received the care from their parents, your assessment is predictive. You have no evidence of the care the child has actually received. Your assessment is based more strongly on likelihood than it is on something that has already happened. The pre-birth assessment is a modified version of Risk 2. And as with all the tools, there are guidance documents available to explain how to use it. Sometimes there are specific areas of care that you'd want to assess. One of the key ideas in the risk model is that you have a library of other tools you can use if you want a specific focus. Examples of some of the tools that are used most often include capacity to change and neglect. The change tool includes a 7 steps of contemplation checklist, a continuum of motivation screen, and a change tracking tool. It helps ensure that a parent is ready to change, that they have strong internal motivation to change, and that the practitioner knows at which of the stages of the change they are. In the area of neglect, there are two tools. Home conditions focuses on the physical condition of the home and its effect on the child, whereas the graded care profile takes a wider perspective of neglect, including how responsive a parent is and how they demonstrate esteem or love for the child. Once you have worked through video 3 of the Assessing Risk of Significant Harm course, please progress to the next part, which is video 4, Exercise in Risk Screening. In this next video, we'll introduce the Risk 1 screening tool, and you'll have an opportunity to screen your own caseload.